conventional relationship to the extent possible. So, in other words, it can be really tempting to like just talk to your client's sister or mother or social worker or caseworker, and sometimes that is necessary, but make sure you're also always continuing to treat your client as if they were just a conventional client. Because unless they have an legal guardian, it is their case and it is their decisions to make. Next is accommodating clients. I think most of you are probably attorneys and you're familiar with reasonable accommodations, and I'm not specifically talking about reasonable accommodations because reasonable accommodations have a whole process and requirements and laws, and I don't think that makes accessible. That's not really that accessible. So just when you're thinking about working with your clients, just think about providing an accessible office, accessible representation. If they can't come in the morning, even if it's more convenient for you, have them come in the afternoon. If they prefer the phone, if they prefer in person, just try to maintain flexibility if that's necessary in order to have a good attorney-client relationship. And then the last concept is least restrictive alternative, and again, that's a legal concept from the Americans with Disabilities Act, Fair Housing Act, but the concept is important because again, it requires you to respect your client's autonomy. So for example, if you do have a client with diminished capacity, you don't immediately go to getting them a legal guardian. You might do a GAL, or don't move for a GAL if what the client really needs is just for you to spend more time with them. Don't refer to APS for a representative payee if all they really need is help setting up automatic bill pay. So least restrictive alternative is just sort of that concept, is to protect your client's independence and autonomy as much as possible when you're making decisions about how to represent them and how to help them. Okay. So establishing the relationship is, some of you I recognize are experienced attorneys, but I remember when I was a new attorney, no one ever explained any of this to me, so I'm going to try to, it's going to be probably basic for some of you, but not for all of you. So your goal is you want to be clear to the client that you're going to listen to her issues and explain the process and create an alliance, but that's not always easy if you're doing high volume intakes and representation. Remember that legal services office is like an ER to your clients. They're in crisis, they often have more than one crisis, and a lot of times they'll come in and just dump everything that's going on in their lives onto you for a lot of reasons. One of those reasons is sometimes it's not clear what's related to their housing issue and what isn't. So one of the ways you establish your relationship is to clarify your role, and you want to do that more than once. I think a lot of times you'll see people say, oh, I'm your attorney, I'm doing an intake, we're going to talk today, and somebody's going to get back to you next week. And so that doesn't really mean anything to a lot of our clients. What is an attorney? If I'm talking to an attorney, does that mean you're my attorney? That happens a lot, that someone meets with an attorney and assumes that you're my attorney. So you want to clarify, are you an attorney? Are you a paralegal? Are you doing an intake? Are you advising them? And explain what that means, because otherwise you can run into issues with people making assumptions. I talked to someone that means they're my attorney. You want to give the client time to tell their story or tell you what's on their mind, even if you're in a hurry. And like I said, if you're doing right to counsel intake, you may not have time for that. And so what I recommend doing if you can't is to make an appointment and let the client know there will be time to tell their story later. So one of the things you see a lot with our clients is, again, sort of like a trauma dump. They don't know how much time they're going to have to talk to you, and they don't know when they're going to be able to talk to you again, so they'll try to push out as much information as possible when they first meet you. And it's too much, and you have to give very specific information, and so telling them they will get a chance to do that can help redirect to what you need to do in the early stages without causing them more anxiety and wondering, like, is this person ever going to listen to me? Does this person even care what's going on with me? again, explain things even if they seem obvious. When you say you're investigating the case, what does that mean? What is a hearing? What is a conference? What is APS? What is HRA? What is an OSC? Don't use legal terminology. Don't use acronyms, especially the intake process. I'm not in right to counsel anymore, but I was for 5 years, and I found our intake process confusing, and so I think just being really, really clear, like, this is what happens, this is when the next step is gonna happen, this is when you're gonna hear from someone. And it can be really hard to do that in the right to counsel intake, I know that. But taking the time to do that can just be super helpful in alleviating the person's anxiety, because I don't know about all of you, but I like to know what's gonna happen next whenever I'm dealing with something stressful. And return phone calls and emails quickly, clear when it is you will do so. When I started at Legal Services, the executive director told me that the number one reason why people file complaints against their lawyers is because they didn't return phone calls. And she said, always return phone calls. So just going to emphasize that again, return phone calls. Does anyone have any questions about any of that?
Yeah, so I think it's, can everyone hear me? I think it's easy, especially for more experienced practitioners, to be like, okay, this is the same, it's very routine, it's very rote. Like our jobs, when you boil it down to this like most basic aspect, very routine, right? And I think it's hard for people to remember that while there are things that we see all the time, our clients certainly don't see them all the time. And so that's something that I have challenged myself to do, is really recognize that just because you know what you're doing and have done this 14 or 15 times in the past 3 months doesn't mean that your clients have done that, right? And so I think that's a really good mindset to put yourself in when you're dealing with clients in general, and when you're dealing with clients who have a more difficult time understanding or engaging with you. So creating structure. I think that the most important part of that is to sort of like establish, sort of on top of what Dinah said about creating or like setting expectations, creating structure. We're having this meeting to talk about your answer, and we're gonna go over all of your defenses, and at the end of this, you're gonna sign your answer. It alleviates anxiety. It's not just, I have a meeting with my attorney, I don't know what I'm talking about, I don't know how long it's going to be. And it sets the tone of the meeting. It also shows respect for your client's time, right? Like, they are a fully formed person who have other things outside of the housing crisis that they're in. And establishing what you're going to do during the meeting shows them the respect they deserve, right? It also shows them that you understand what's going on with their case, right? I think that it's, you know, especially with right to counsel providers, you have 60 cases and a lot of the legal issues overlap, but when you meet with your client, it's important to, even if, you know, review their case, even if it's 5 minutes beforehand, to show them the respect that you understand what's going on with their case, understand what's going on with them, and it's just the bare minimum, right? But again, sometimes very hard to do. And the same thing with phone calls, right? We're gonna speak on Wednesday, we're gonna go over the timeline of the events that took place and why, you know, we have to go to court next week. I think that it's important to establish a time restriction, right? I have an hour to speak with you on Wednesday. Every Wednesday we can speak for an hour about something that alleviates your anxiety and helps you stay engaged with your case. But know that if we speak for an hour every Wednesday, I may not be able to speak with you for the rest of the week, right? Sort of creating a structure to make people feel more comfortable. I speak to my lawyer on Wednesdays at 1 o'clock from 1 to 2. Anything I need to talk about with her, I talk to her then. Again, I think that everything that we're going to talk about is really interconnected. Establishing sort of like a timeline. Okay, after we file your answer, this is what will happen. After we make this motion, this is what will happen. The purpose of this motion is to get discovery to show that your landlord hasn't overcharging you, or whatever the sort of, just just because we know what we're doing doesn't mean that our clients know what we're doing, right? And that's another way to show them respect. It also helps, it'll help you, right? If you are saying, on Wednesday we're meeting at 1 to go over your answer, at the end I have 10 minutes to answer any other questions that you might have. It helps you, and it helps you not only in that you're getting the work done that you need to get done for your client, it also will be less frustrating to you and your client by sort of establishing what you're going to go over and then leaving some time at the end for other questions, concerns, etc. If you feel that, if you or your client feel that there isn't enough time or anything, obviously schedule additional meetings or phone calls, but I find that, especially with clients that have a high level of anxiety or have difficulty sort of understanding and engaging with the process, setting up a schedule and really creating a structure with them has worked very well for me in my practice. Any questions before? I guess we can save questions till the end, or I don't know. Really, all the advice that we're giving you is out the window when we're coming to present this to you.
This next section, oops. Okay, setting boundaries. I think this section can come across as kind of harsh sometimes, like it's a lot of like, you know, how to limit your client's contact with you, which seems mean, but it's not intended that way. It's more about how to have a sustainable legal services practice where you aren't constantly having, you know, people come at you and be reactive all the time. And so again, so you can sort of plan things out. And boundaries are also good for clients, quite frankly, because you serve a limited role in your client's life. You're not a mental health professional. I assume there are no social workers here. And I think sometimes in our desire to help people, we can create relationships with our clients that can make them feel like we are more to them than we are. And then your relationship is going to end at some point when the case is over. And then if they've been relying on you for like emotional support or to talk through their other problems, then you're gone. And that's hard for them. And so I'm not saying that you should just be, you know, cold professional and put your clients off when they want to talk about their problems, but I don't think it's good for clients necessarily to get into these like very deeply personal relationships. And that's not always going to work. I've had clients that I love, and I did develop relationships with them. And HLP has a lot of clients who come back over and over, and so I'd see them again in a year or two. And that's fine, but it's just, you know, it's just something you want to be conscious of. And I think that it can be hard and make people feel like they're being like mean if they are, you know, tell someone, you know, I'm sorry, I'm not able to talk to you about that, or I'm not able to help you with that issue. And one of the things that made me realize this in my own practice was I had a client who was going through a divorce. There was domestic violence. As I'm sure you all know, it's very difficult to find a free attorney for divorce. I told her, you know, I don't do divorces. MFG does not have a family law practice. We can't help you with this. But, you know, when you spend a lot of time in court sitting there with your client, she would talk to me about her divorce. And, you know, I would listen. And then after a couple of months, she said, so can you represent me in a divorce? And I said, no, I can't. You know, we talked about this. And so she thought, you know, if I just was sympathetic enough, that she could convince me. And I didn't realize that was what was going on. And like, I don't feel like I necessarily handled that badly. Like, you know, we're not mind readers. But it definitely struck me as like, you know, oh, I could be giving my clients an impression that I do not intend to give them, that I can, you know, I can offer them more help than I'm able to give them. And boundaries are also good for you. You know, I think there's a lot of focus on clients, which is good, but I know with right to counsel also there's a lot of attrition and burnout, mental health issues, and, you know, having clients texting you on weekends or in the evenings, it affects us, it affects our mental health, it affects our ability to do this long term. So if you want to be a legal services attorney for a long time, maintaining your own boundaries, not doing work outside of certain hours, and limiting your client's ability to contact you on your personal devices is, to me, extremely important. None of my clients have my personal phone numbers. I know some people do that. I don't do that. It also helps, so everything I said so far, I think applies to all clients, but some of the initial stuff that we're saying applies to all clients, but if you start your relationship with all your clients this way, when you find out that you do have a client who has diminished capacity or who's anxious or who's angry or who's abusive, it's a lot easier to deal with that if you've already established these sorts of practices. Whereas if you're just all like free and open and then your client curses you out one day and then you start setting boundaries, then it seems kind of like you're targeting them, and it can make them defensive and more angry. So I think that's why it's good to start from the beginning, because then they're not going to come back and say, oh, you weren't doing this a month ago, and now you're doing this. Why are you doing this? So it's good to start all of this early, so that if you do need to set tighter limits or tighter boundaries, it's already something your client knows to expect from you. Which gets us to the next point about setting limits in the length and frequency of contact. Again, when you've got an anxious or an angry client, this really comes in. The people who send you long emails at 3 a.m. or who leave you 6 voicemails in a row, at 4 a.m. You can tell your client, like, I'm not going to listen to all of those emails or all of those voicemails, or I'm not going to read all those emails. In certain situations, and some you might, but if you've got a client and you know that they're sending you long emails that contain delusions or things you've discussed before, repetitive, you can skim them, but you don't have to get into a back and forth about every single thing that goes in them. And then you can say to your client, like Meg is saying, we're going to talk on Wednesdays. And so that way, if your client is bombarding you with contact, you can say, we're going to talk on Wednesday. And then you talk on Wednesday. And that's been very helpful for me, because it's very hard, if you're getting like anxious or angry emails, not to respond. And then what I've discovered is that then you end up in a feedback loop sometimes. There's one, here's one, there's one. And so, just saying, we have this set time to talk, we're going to talk then, can be really helpful. If you do have a client who is sort of flooding you in this way, another way to set boundaries is to have phone calls rather than in-person meetings. It's a lot easier to end a phone call than it is an in-person meeting. It is possible to hang up on a client. I don't recommend that, but like if you have a client who's cursing you out or is escalating a lot, I will hang up on clients if I tell them I'm going to do it. Like I don't just hang up on clients, but you can say this conversation is not productive. We're not getting anywhere. I'm going to hang up now and I'll call you back tomorrow. And I usually do that, give them a couple of chances to maybe de-escalate, and then if they don't, then I hang up. And that's something I didn't learn until a few years into being a lawyer. And when I look back on the first few years that I was a lawyer and the amount of time I spent on the phone with clients who were, maybe we weren't getting anywhere. They were yelling at me, they were cursing at me. It wasn't good for me, and it wasn't good for the case. We weren't doing any productive legal work. One key though is if you do set sort of limits on your client, like I'm only going to talk to you on Wednesday, you have to tell them that, or else they're just going to get more anxious. Like I've sent this lady 15 emails and she's not responding to me. I need to send her 15 more. So tell the client, I'm going to talk to you on Wednesday. Please feel free to keep sending me emails. I'm going to respond to them on Wednesday. put that in your notes and make sure your supervisor knows if you have somebody who might escalate to your supervisor. Because, if the client contacts your supervisor and says, I've left Dinah 10 messages in the past week and she hasn't gotten back to me, that doesn't really look good. So just, communicate with your client, make sure you made a note, and communicate with your supervisor. And that way everybody knows what's supposed to happen.
And also, no one ever says, I left Dinah 10 messages in the span of 10 minutes over the course of the week. It's never the whole truth, right? And so it's important for your supervisor to know the boundaries that you set.
And if you do that, you have to keep the agreement. If you tell the client you're gonna call them on Wednesday at 1, and then you don't call them on Wednesday at 1, they're going to be more anxious, more angry, they're not gonna trust you. So, do a calendar reminder, do whatever you have to do, because if you tell a client who is, escalating this way, or is anxious, or is manic, then you're gonna call them, and then you don't, it's just gonna make the situation worse. And I think we say this a few times in this training, empathizing with clients, acknowledge their anxiety and anger. I think most people know that like telling someone to calm down is like the worst thing you can do when someone is really upset, so don't do that, but it can be hard to be on the receiving end of that sort of anger or anxiety, so acknowledging it is important. I also think there's a place for apologizing, and again, especially when I was a young attorney, apologizing made me feel very vulnerable, or like I was admitting that I was making a mistake. I didn't want to do that, but not necessarily even apologizing for a mistake you made, but just like apologizing, like, I'm sorry, housing court is terrible. It's really awful that you have to go there and sit there for 4 hours waiting for your mental attorney. I'm sorry you're having to go through this, and I'm sorry I'm not able to make it better for you. I found that makes some of my clients feel a lot better. Just to acknowledge what they're going through, that it's horrible. And then last, ask the client if there's anything you can do to make things easier. Like, if morning meetings aren't good for them, can you do afternoon meetings, office versus phone? Do they need a lot of breaks? Would it make them feel better to bring someone? And try to work with them. Would it make them feel better not to meet in your office? I had one client who felt like my office was occupied by a dark force, and so we didn't meet in my office. And that was all it took. Like, he was a lovely man, and we didn't meet in my office, and we had a great relationship, and I kept from being evicted like 6 or 7 times. And sometimes that's just what you gotta do. Any questions on that section? Oh, there's a mistake.
It's just the one. Yeah. Okay, so refocusing the client. So you've gotten to a point in your meeting or your telephone call or court appearance where it seems like your client is having trouble focusing or is maybe perseverating, really concentrating on something that you've gone over what feels like a million times, right? And so, or I think that a lot of people see like age-related cognitive impairments, right? Someone is telling you about how they came to New York in the 1950s, which is a beautiful story, but not particularly relevant to their case and what they're going through. And so you want to refocus them, right? And sometimes you can't. But I think that listening is very important, right? If someone is telling you about how they came to New York in the 50s, they may also be telling you about their time in the apartment, how long they've lived there. There are other things to glean from a story that someone's telling you than just the story they want to tell you, right? And sometimes that's an accommodation that you can make for your clients. They're just gonna talk to you about their life in their apartment, and you will take what you can from that. But it's also not I think that, particularly for women, we're sort of conditioned to not interrupt people and as they're telling us something, right? But it's not inappropriate or rude to interrupt your client and refocus them to what you were talking about, right? You are sort of like Dinah said in the previous section, your existence in your client's life is not to be emotional support or a stand-in for a therapist. While it does happen, that's not your role, right? Our roles are very discreet. We're helping someone with a legal issue, and that's our area of expertise. And your goal to keep your client housed or as close to that as possible, and their goal to stay housed is often not accomplished through sort of like being polite and dancing around things, and too much like unfocused time, right? It may be lovely to listen to your client with the 3,000 square foot loft in Tribeca tell you about how Tribeca was in the 1970s, but that's not serving your shared goal of keeping them in their apartment. And sort of bouncing off what Dinah said earlier, like it doesn't help your client because you sort of become the stand-in, not just their lawyer, or their social worker, their friend, whatever. And I'm also very guilty of having clients that I really love and care for. Not that that's a bad thing, but we are their attorneys, right? That's our job is to keep them housed, help them with their discrete legal issue. So when when someone is sort of getting off track, you interrupt politely, say, "I'm so sorry, Mrs. Smith. This is a really interesting story. However, what we need to talk about is your rent payments." And sort of refocus in a way that acknowledges that they're telling you this story, but also that you are there for a different purpose. And you can remind them, "Thank you for telling me that, Mrs. Smith, but remember, we're here to go over your answer, and we need to finish X, Y, Z," and sort of redirect in a way that is polite but firm, I think is the best approach to that. Do you have any?
Yeah.
I mean, it's hard to do, but it's easier. I think that a lot of the things that we're talking about are harder to do, but when you think about it, it makes your life so much easier.
Yeah, and I think a lot of the stuff in this training, they're guidelines and it's called techniques because there's no hard and fast rule. And one of the most challenging clients I ever had was a succession case in the village, and he lived there since the 80s when it was, gay artist neighborhood, and his building was bought by a very famous fashion designer. And this was when people could evict tenants for owner's use. So she was going to make it into a single family building. And so he had this rich lady come take his home. And it was unbearably traumatizing for him. And owner's use cases, for those of you who have not been doing this for that long, were horrible cases. Like they were completely unfair. There's not a lot you could always do. And so the only way I could work with him was I did spend a lot of time listening to him tell the stories and talk about the trauma he'd been through in the building, his life in the building. And I think if I hadn't done that, I probably would have had to move to withdraw because he also could be quite abusive sometimes, and he did send me a lot of angry, manic emails in the middle of the night. But we were able to sort of work out a tenuous relationship, where I would spend the time, and this was also before I was counsel, I was able to spend the time talking to him about all of this, and so he did eventually trust me. He also did continue to send me abusive emails, but that was a symptom of his mental illness, and when he wasn't having that middle of the night anxiety, we got along fine. I was able to get him a buyout, everything worked out, and that wouldn't have happened if I hadn't spent the time listening to him. And so, a lot of this is, developing your own judgment and developing your own personality. Like, people have different ways. Like, your own personality obviously is going to affect how you interact with your clients. And sometimes you can't refocus someone, and when that happens, I think what I do is I just let them talk. and just write it down. Anytime they say something that seems like it might be relevant, you write it down. Because, you know, if someone has advanced dementia, or if someone is delusional, or if someone is, you know, very, very symptomatic and mentally ill, refocusing them just may not be possible. And so then you just sort of have to do the best you can. Anything?
One of the things I think that's hardest now for me in the supervisory role is when one of our attorneys is experiencing what you just described, where it can be abusive at times, or it can be hard to deal with. And it's especially hard to want to withdraw from those types of cases because you know the client's experiencing some sort of mental health issue that, you know, is contributing to obviously behavior. But what are some of the things that you've done to, I guess, still be able to maintain some sort of attorney-client relationship that doesn't feel like you're just listening for hours, or, you know, in some sort of abusive situation? Obviously, you mentioned one where you're on the phone with someone telling them that, like, you know, this doesn't make you productive anymore. That's, you know, take this up another time, maybe tomorrow, or whatever. But when you're in person with someone, you can end the conversation. But I found that it's harder to de-escalate the situation. It's also hard at work where things are already hectic. Do you have any thoughts or suggestions on those particular situations where you're in person intake, or when you're in the work experience?
Does your office have a social work department?
Very minimal. Yes.
If I have a client who I know is likely to escalate in court, we also have a small, like, social work department, and so we have social work interns, which I think probably everyone has a social work department has, and so sometimes we can just have a social work intern come and spend the time with the client, so they're not just by themselves waiting, and that helps a lot. I sometimes have the client not come to court at all. I think that can also be useful because, you know, if your client's in court and you're in court and the landlord wants to settle the case and the judge wants you to settle the case, they're gonna want you to write up a stip and sign it then. And if you have a client who's really not getting it for whatever reason, I don't wanna sign a stip in court, you know, that they don't have, I want them to have time to think about it. And so sometimes I will tell my client, like, don't come to court, we're gonna talk, I'll talk to the landlord's attorney about this and try to work out a stip, and then I'll talk to you, you know, I'll call you after court and we'll go over the stip. Obviously, if you have a trial or something, that doesn't, I don't know, I can't remember, I don't think I've had a trial in a while with a client who's like that.
Before COVID, I had a client who was, and it was a horrible case. My colleague and I represented 6 men who lived in an SRO that was vacated because the owner had neglected it for years and years and years. And he was so frustrated. The day that the trial started, he sort of mentioned offhand that it would have been easier to just bring a gun into court. And he was joking around. I think he was probably using, I mean, we all use black humor, right, to cope with our jobs. I think that he was sort of doing that too. Luckily, no one else heard him besides my colleague and I, but that's hard, right, because you want to take it seriously, but at the same time, it's an incredibly frustrating situation that you're in, and you have to go to trial to assert your rights. And so we asked him to just sort of like go and sit by himself and sort of calm down, essentially, which seems a little infantilizing now that I'm saying it out loud. But I think the frustration was so great with all of the trauma that he and his the other tenants that he lived in the building with had experienced, that I think he was just sort of acting out in a way that made him feel better at the time, but could have been really terrible for him. And, you know, I said, if you have any breathing techniques, just sit and breathe and think, because ultimately saying something like that won't serve any purpose beyond getting your frustration out, and I think that there's a better way to do that. I've had clients in doing right to counsel work follow me around and yell at me, and that's hard, right? Because we shouldn't experience abuse in our work, but we do all the time. And it's another thing where you say, I'm going to go to the 4th floor right now. I'm going to take care of another case. I will be back in 20 minutes, even if I'm not done, just to check in. If you don't feel like this is a productive use of your time, you can leave, but I understand why you want to be here. I mean, I don't have a perfect solution, and saying it out loud, I realize I'm not even giving any tips at all. But I think that, and I don't know what it's like to be a supervisor, like telling someone else how to deal with this. I think that it really is a judgment call in the moment, right? That you know your client and you know how they may or may not be able to calm themselves down. And I think that that's not a great tip, but that's how I practice.
I mean, I think it is a tip to say, like, basically disconnect from your client, you know, like, in the phone call, in the meeting, go to another floor, ask them to go to another floor, ask them to take a walk, tell them to take a break. Like, you know, it can help. And having a supervisor talk to the person can help. Like, I've noticed, I think sometimes people are like, oh, I'm talking to the boss now, you know, and that makes them feel like, oh, you know, they're talking to somebody with authority. So I've definitely had situations where my supervisor talked to clients, told them the exact same thing I told them, but they felt a lot better about it. And also just, I think one of the things, again, that was really hard for me is knowing that I could tell someone, you can't talk to me like that. I'm gonna end this call. And I think there's a distinction between people who can and can't help it. You know, I've had clients who were psychotic, clinically psychotic. They were not able to control the words that were coming out of their mouth. And everybody's different, but for me that doesn't bother me that much because I know it's not personal. It's not a choice that they're making. They're not thinking what they're saying. And then there are people who can control it, and those clients do bother me. But I think that's where, you know, saying you can't talk to me like this, I'm gonna end this meeting, actually works sometimes. You know, if it's somebody who's just kind of being a jerk or has like low impulse control, you know, having some limits and some repercussions can work. But I think there are people who genuinely cannot control what they're saying. And that's difficult because like I'm usually okay with that, but no one has to be okay with that. Like I'm not gonna tell people just to take it. Yes. So especially if you're in an in-person meeting, yes. So body language is really helpful. So having an open posture, relaxed shoulders, leaning back. You know, if you do this, you immediately looks tense. You know, you're looking tense, you're leaning forward. So what I do if a client is starting to escalate is like I focus internally and like on just trying to relax and speak slowly and calmly and take time before you respond. And that's, in my experience, surprisingly effective because, you know, if someone's escalating, sometimes they want you to come back, you know, they want that train to go. And so if you can stop that, they're not getting anything back from you, and so it's hard to continue. Some people will, but, you know, I saw an attorney in my office do this really well with Brian Stark. I don't know if you practice in the Bronx. He was just escalating, and she just looked at him and said, it's not that deep. just, like, what do you say to that? How do you respond to that? He backed off because he wasn't getting what he wanted. And so that, I remember watching that thinking, like, that's good de-escalation. And again, emphasize and acknowledge the client's feelings, apologize. I said this already, but sometimes just saying, like, you know, if they're yelling at you because, you know, they thought the case was gonna settle and it didn't, and they stressed them out, they have to go back to court again. Like, I'm sorry, I thought we were gonna settle. I understand this is really frustrating. I wish I could have gotten this done for you today. Taking a break, like, again, anything you can do to sort of put a wall between the, can't find the words. You know, anything you can do to interrupt the escalation helps. So if they're in court, ask them if they want to go outside and walk around, tell them you're gonna go walk around, in the meeting, end the phone call. In my office, we have a, I don't know what it's called. It's not called a dangerous compliance procedure, that would be a terrible name for it. But it's basically a process that if you have a client in the office who's like yelling or escalating, there are steps that you're supposed to do. And so one of them is, you know, you go to the interview room where your case handler is with the client and just take your hand and say, hey, is everything okay? And that's a version of taking a break. Like, it's just like interjecting something in there to stop the escalation. And it also lets the client know that there are other people around and there are other people watching and hearing what's happening. And so sometimes that will give them pause and they'll stop escalating. And then if you're not able to de-escalate and they continue to you know, engage in abusive or angry behavior, then again, just end the appointment. Send them home, you know, if you're in court. I would tell someone, like, to leave if I thought they were gonna do more harm than good, staying in court that day. Again, I don't think I've ever had that come up when I was at a trial, where you can't really tell someone to go home. But, you know, at a certain point, you're probably gonna realize that there's nothing you can do, and you just have to end whatever's happening and hope you can come back another day.
No, I mean, it's hard, right? It's so hard, but sometimes you can't de-escalate, and it's better for the relationship to just end things. I find that slowing down your breathing really helps. It helps you relax, and so often people sort of mimic you, and so then everyone is breathing deeply and slowly, and it does help.
Yeah, it's surprising to me how much focusing on my own body language and my own breathing and my own tone of voice helps. Also, just because I think it's natural. Somebody's yelling at you to get defensive and to want to, like, you know, get tense, and so being conscious of your own response can really help a lot.
Having a toddler has really helped me engage with my clients who are stressed or irrational, because it's just like dealing with my child.
Any questions or anything on that? De-escalating?
What if they're saying something really irrational about the legal system and that they won't listen to your logic? How do you deal with that?
Like delusional, right? Or
Or they just think, oh, I'm just going to get screwed. I don't believe that your plan is going to work. You know, that sort of thing.
I think it's important to acknowledge that, right? Like, the legal system sucks. Like, it's stacked against tenants in so many different ways. We also live in an incredibly expensive city that's getting more expensive. The government, from very local to federal, doesn't really care about poor people. Like, it's okay to say all of these things, right? Like, it's okay to say, I recognize that you don't have enough money to live in New York City, and that I'm really sorry. Right? Like, you can critique capitalism to your clients, that's fine. But again, I think acknowledging that that the legal system sucks and the system that we are a part of is not very just is really appropriate and often really helps connect with your client and acknowledging that this is a terrible situation and you're trying to help them as best you can. And it might be true that what your legal plan is might not work, right? It's hard to admit that, but if you have a really hopeless case, that is often true.
Yeah, I think it would depend on the situation. If I thought we had a strong case and they were saying that, I could maybe, review the plan, or, you have this really great defense. I successfully argued this defense before, this is a good judge, say that. So if it's not the kind of situation Meg is talking about where it is a helpless case, I would probably just go over some, what we planned, what the defenses are, what the strengths are, what the next steps are.
Okay, this is the part that our social worker usually does, but we'll forge on. So delusions and hallucinations, right? Have a client that is telling you that the landlord is putting microwave heat into their apartment and glass into their closet, and that's what's going on in their case. That's the only legal issue. And so it's important to never argue with the substance of that delusion, right? The landlord is probably, it's entirely possible, right? We've all seen some crazy stuff. The landlord is almost 100% not putting the glass in their closet. They are probably not putting microwave beams into your client's apartment, right? But it doesn't accomplish anything to argue with them about that, right? It just doesn't. It doesn't help your relationship. It certainly doesn't disavow anyone of this delusion, right? There's no point of arguing the substance of it. But it's also important not to, just because someone is having a delusion or a hallucination, assume that they don't have capacity, right? Someone could be in the midst of a very discrete mental health episode, or it could be that just this one portion of their thinking is compromised, right? The glass in my closet exists and my landlord has put it there. And that could be it, right? They could be exceedingly helpful in other parts of the case. I just don't think, it just doesn't serve anything to assume that they lack capacity. And so it could be that your client says, I need you to help me with the glass that's in my closet, right? You can't, you're a lawyer, right? Even if there were glass in the closet, that's not something that you can help with, because something that I always do is say, this is what a judge would be able to do in this situation if we took this case to trial. They can't argue, or they can't order your super to be nice to you. They can't order your super to say hello in a particular way. If a judge can't do something like that, it's very unlikely that I can do that, right? And so I think that it's better to explain that you have a discrete role in their life, that housing court has very limited jurisdiction to enforce things, and that you are only there to help accomplish that, right? There's not a legal remedy for every wrong. How often in an HP case does your client get upset because they're putting vinyl flooring down that they don't like, right? I feel like one of the things that I say all the time is they just have to do it. It doesn't have to be good, right? And that sucks. That's shitty. That is one of the worst parts of our job. Our landlord just has to fix something. They don't have to make it look good or even fix it in a way that it won't break again in 2 months. And that I think is a really important thing to sort of get across to your client. Some things we just can't do. We just can't. And that was a hard thing for me to learn as a new attorney. And it continues to be hard as a more experienced attorney. Then sometimes if your client is really in the midst of some pretty intense hallucinations or delusions, you may need to refer someone else somewhere else, right? I think that probably, MHLP deals with this more than our housing unit, but I mean, there are all sorts of, not all sorts of resources, but there are other resources for people who are in deep delusions or deep hallucinations, right? You can, there are places that have more experiences or processes with people who are having delusions or hallucinations. Trying to think, there's like the SDNY Pro Se office is supposed to be amazing when it comes to dealing with people, or like helping guide people through a pro se federal process. Yes.
Sorry, what is SDMI stand
Oh,
for?
sorry, the Southern District of New York, it's federal, so it may not be appropriate in all situations, but their pro se office is like, it's like staffed with lawyers who could be social workers, essentially, it's incredible.
Yeah, the magistrate, a few years ago, the magistrate who was in charge of it, I don't know if she's still there, Lois Bloom, came and talked to us, and she said, you know, a lot of what they do is people who come in and want to sue the IRS or the CIA or the FBI or something like that, and, you know, they know how to do that, they know how to deal with that. You know, she said, don't feel bad about sending people to us. That's their job, is to help people file pro se lawsuits. It's not their job to say, you know, this has merit or not. And she said, you know, their staff is practiced with this. They know how to do it. I thought that was really interesting. The City Bar Justice Center also, we have a referral line. A friend of mine used to work there, so I know that they also have, you know, they get these calls from people who no one can help, and they're used to dealing with it. So if you have someone who wants to sue someone based on what you think is a delusion, don't feel guilty referring them to the city bar. Does anyone here work for the city bar? Or the Southern District, you know, like, it's not our job to convince someone that they don't have a lawsuit, you know. One thing I did want to say about hallucinations and delusions about the capacity issue is the client I mentioned earlier who thought my office was occupied by a dark force. He had numerous delusions. That he was being surveilled by his landlord, and so before he decided my office was occupied by a dark force, he thought his landlord knew where he was and was watching him. And so when he came to my office to meet, he asked me, you know, not to reserve the interview room before he came in, because then the landlord would know where we were and listen. And so when he came in, you know, I would just say, let's see what room is open. You know, I didn't reserve a room, and that was fine. And I didn't leave voicemails for him that said anything substantive, because he thought his landlord couldn't hear them. But other than that, he had no capacity issues whatsoever. He could make decisions in his case, he understood his case, he had great records, he was a great client, he's one of those clients who comes in with like a folder that's full of everything you need. So I think, especially for people who don't have a lot of experience with mental illness, I'm just gonna start calling them delusionations. Delusions and hallucinations are they're dramatic, you know. If you watch a Law and Order, people who have delusions and hallucinations are dangerous. And that's not necessarily the case. You know, people can have these and be able to make decisions on their case and be able to, you know, direct you on the case. And it's just important not to assume that just because someone has like a dramatic symptom that they don't have the capacity, you know, to make decisions in their case, to direct litigation. Any questions on delusions and hallucinations?
Did you answer that, how to explain why you can't exist?
Yeah, that was the sort of what Meg was saying about the limitations of the court system, limitations of housing court. also sometimes talking through like the burden of proof with a client. So if it is housing related, you know, talking about, okay, how would we prove this? You know, when you go to court, you have to be able to show certain things. You know, what do you have? What can we get? And then just telling the client sometimes that, you know, a judge doesn't know you, the judge doesn't know the landlord. They're gonna listen to what the landlord has to say, and they're gonna listen to what you have to say, and they're gonna believe the landlord, I think. I've told people that, when they want to litigate something that does not seem to be real. Okay, so referring for treatment. Most of my clients, mental health law project, are in treatment, but I'm sure a lot of housing clients are not. So one thing to be aware of is that a lot of people do not want it suggested to them that they have a mental illness. There's a lot of stigma. People who have been through the mental health system a lot of times have had traumatic experiences. If you have a client who's been involuntarily hospitalized, that is a very traumatic experience. So if you do have someone who you think might benefit from mental health treatment, the way I usually bring it up is, you know, this is really stressful, what you're going through. I can't provide you with the kind of support that you need. You know, I suggest, have you considered, you know, seeing a therapist, somebody you can talk to about this? And even with that, a lot of times clients will say, what do you think? I'm not crazy. But you know, if you introduce it sort of gently, it goes over a little better. Also, sometimes you might want a client to see a doctor because you want to make a reasonable accommodation claim, or you want to do a disability defense. And in those cases, I just tell the client, like, you know, I think you're going to need some medical records for this, and I advise you to go see a doctor. And again, that can sort of get around the stigma issue. You know, you're not saying to them, I think you have a mental illness. It's, you know, if you want to keep your emotional support animal, if you want to move to a lower floor, if you want to, you know, whatever, you have to have evidence to support it, and you can only get that evidence from a doctor. And then establish a social work department. I think more places have that now. When we first wrote this training, a lot of places did not. And honestly, having a social work department is the best thing ever.
Okay, so involving family members and treatment providers, or friends, really. So I think that, like, obviously the big key thing here is you need your client's permission. And you need your client's permission for every different person, every different time you're gonna do it, right? Your client can revoke their permission at any time. I find that it's best to say, I would like to speak to your mother about XYZ issue. Can I do that? Is that something that's okay? I would like to speak to your treatment provider about getting a letter to bring to court as part of proof for this defense, right? Just more discreet than just saying, can I talk to your mother or your best friend or your psychiatrist about your case? It goes to the sort of like establishing boundaries, setting a routine, everything really reinforces itself, right? And I do try and ask permission every single time I want to talk to this person. It's also really helpful sometimes when their friend or family member who is concerned about them continues to call you. It's sometimes appropriate to just be like, I cannot talk to you. I do not have my client's permission to talk to you. I understand that it's frustrating to you. You can keep complaining, but I can't speak with you.
What happens if the tenant is not in a mental capacity to give that consent? Or they give that consent, don't remember they gave that consent? Or what happens in those situations?
Right, that's pretty difficult, right? And often I think that there are times where it's really tempting when you recognize that your client has diminished capacity. It would just be so much easier to talk to their sister or treatment provider or neighbor that is just so involved in their case. it's very tempting to do that, right? And so I think that the way that I approach it, and I think that ethically, like, the rules say that you should approach it, is that sort of, it's like, almost like continuing consent, right? Like, your client at one point was able to give you consent, maybe they can't anymore, and that's when you sort of need to stop ethically. But like I said, it's challenging to stop, because oftentimes their friends or family members or treatment providers are more helpful than not. And sometimes, like, right, sometimes as an accommodation, it is, and so this is like sort of where I contradict myself. There are things that you can do without your client, right, in terms of their case and their defense. If you've gotten, let's say, a waiver signed off on, right, you can have your client sign a waiver where you can talk to their doctor about their mental health treatment and sort of formulate a plan or a defense that way. But again, the way that I practice, and I think that the way that ethically we need to practice, is that it's this continuing idea of consent.
Can I just say-
Yeah.
So I think it sort of also depends on what you want from them or what they want from you. A lot of times, what family members and treatment providers can do for you that your client can't is just like getting documents and like, you know, providing like a history. And so there have been times where I have permission to talk to a family member or a friend who is sort of their caretaker, and you know, I needed help getting succession documents or one-shot documents, and I would ask that person, you know, can you get these for me? And I felt comfortable with that, unless the client told me not to. But something like that, I just getting documents like this, I felt okay with. There's some other things there.
Well, it's not just like, in that example, right, you're not discussing the substance of the case, right? You're simply saying, I need this, I need these three things, can you help your friend or your client get them for me?
Also, yeah, the direction of the communication. Like, I can tell someone, you can talk to me you can tell me stuff. I can't tell you stuff.
Yeah.
And I do that with doctors sometimes, like if I have not been able to get a hip release from a client, for the doctor to talk to me, but I know the client is giving me verbal permission to talk to the doctor, sometimes I will contact the doctor and I'll say, I don't have a hip release, so I know you can't talk to me, but I just wanna let you know that this patient is at risk of eviction because, their apartment is cluttered. Can you talk to them about it, you know, next time you have an appointment? Because they can listen to you, they just can't talk to you, Mark.
Also in working with treatment providers, it's sort of like, like Jenna said, they may not be even aware of the issue that's going on, but if you need something from a doctor or a therapist or anything, especially if you need a letter and you needed to say something specific, write it yourself and send it to them. Like, it's one of the easiest things to do, and it saves you so much time and frustration if you say, I need a letter, like, if you think to yourself, I need a letter so my client can keep their emotional support animal, and this is what the letter needs to say, you just write it yourself. Tell the doctor they can make edits as they see fit, but you need X, Y, Z in the letter, send it over to them, and usually 9 times out of 10, they just sign it, and it's done. It's just so much easier when you learn that it's something you can do.
When you're dealing with information that wouldn't necessarily be redacted per se, but is about just by nature sensitive cognitive or mental health information that you would want for an affirmation or for a close party to fill out for an affidavit that would be important for the case or defense, or like in certain circumstances could be dispositive, but the client doesn't want that information entered into the public record. Are there certain kind of middle grounds to be made, or is it really just?
You can move to seal. You can also do a protective order, which I only did once, and it it was ridiculous. I wouldn't say that my experience with getting a protective order was normal, so I'm not gonna really say much about it, but basically a protective order, just like, it's just a stipulation agreeing that certain information won't be disclosed. And I did that in a case where my client had history of sexual trauma. And it was disability defense. And the landlord's attorney would not sign the consent order, and so Judge Christine had to make them sign it. Because why would you sign confidentiality agreement? But also just the motion to seal. So if I make GAO motion, we include a motion to seal with all of our GAO motions.
I've also it's easier now with NICEF, right? But I've redacted sensitive medical information and then like dropped a footnote and essentially said if the judge wants to view this in camera unredacted, that my client and I are willing to provide that, but we're not willing to provide it unredacted on the record. Judge Bactan buys into that, so for New York practitioners, at least there's one judge who will just let you do that. I think it really depends on the judge. Like thinking about the way Judge Finkelstein used to be and the way that other judges are now. Yeah, it really depends. As with everything.
Right, so GALs and Article 81s, GAL is the guardian ad litem, and who is appointed just for a single case for a person who's incapable of adequately protecting or defending their rights. And an Article 81 is appointed under Article 81 of the mental hygiene law, and that's a more traditional guardian. So Article 81 guardian is a surrogate decision maker. A Supreme Court judge makes a decision after a hearing, there's a right to counsel, and the judge is supposed to enumerate what powers the Article 81 guardian has. So it's not supposed to be a blanket finding of incapacity. It's supposed to be like this person lacks capacity in these areas, although a lot of Article 81 judges do not do that. But the question is, when could you move for or advocate for a GAL Article 81 if your client doesn't want you to? Because obviously, we're bound by, we have to represent our clients. We have to be directed by our clients. If you want to take an action that's contrary to your client's instructions or desires, that's not allowed under the ethical rules unless the lawyer reasonably believes the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest. Then the lawyer may take reasonably necessary protective action, including appointment of a GAL or guardian.
On a case where there is an attorney and a GAL, which one would usually take point, or how does the attorneys work? The attorney will take point, okay. And how does the attorney and the GAL kind of work if there are opposing ideas?
That's a great question. We could have 2 hours just on that.
Yeah, the attorney is, at least at MFJ, we only represent the client. We never represent the GAL. Very, very, very rare cases, like if someone comes to us, if a GAL comes to us with a client who does not have the capacity to retain us, we can be retained by the GAL, but the capacity to retain an attorney is very low. You just basically have to have the capacity to say, yes, I want someone to represent this case. So we are always retained by the person, not the GAL. So if we disagree with the GAL, then the GAL can just, like I just don't deal with the GAL in that situation as much as possible. Because the GAL is not a substitute decision maker. That is also contentious. I don't know how contentious it is anymore. It was very contentious at one point. So the client is the client directs the case. a client filed a complaint against me for doing this, but I just think it's good practice to cover yourself. Also, I mean, I think it's an open question why you would move for a JL necessarily. If your client doesn't want one, since JLs very frequently don't do anything. So,
If you wanna vacate a default judgment.
yeah. Yeah, I mean, and the other reason why I sometimes would move for a JL, even if I didn't think they would do anything, is that I want the judge to be on notice that my client has a serious mental illness, and moving for jail, getting jail. Lets the judge know that, because sometimes, if you have a client who is very seriously mentally ill, everything is gonna take a lot longer, and you're gonna end up going to court a lot and asking for adjournments, and some judges will give you adjournments and some judges won't, and I feel like if you have a JAL involved, and it sort of sets you up to go in and be like, Your Honor, my client, JAL, APS, I need more time. And so sometimes I'll move for a JAL for that reason. Also, if I think my client needs an Article 81, APS will not start an Article 81 case unless there's already been a GAL. Because at the beginning of the training, I talked about the least restrictive alternative. So the Office of Legal Affairs at APS, they have to follow that least restrictive alternative, so they will not go straight to an Article 81. And they shouldn't. This can be really frustrating when you have a client who really needs an Article 81 and they're like, oh, we have to move for GAL first. And you're like, a GAL's not gonna do anything.
We're in the trial part. We're going to trial right now.
But they have to do that, it's the right thing to do. So if you think your client's gonna need Article 81, going ahead and getting the GAL appointed and out of the way, I think is helpful. And sometimes the GALs are able to do stuff. I mean, we do actually have like a 2-hour training on JLs and Article 81s. It's not history. Does anyone have any questions about that?
Okay, motions to withdraw. So CLR 321B2 and New York Rules of Professional Conduct 1.6. I think that they're, often the instances, these are sort of like up there, the instances that we move to withdraw, right? There's been a claim that your client insists upon presenting that is just frivolous or just does not, you cannot in good faith present that to the court. I think that probably the last one is the most common, right? Your client fails to cooperate in their representation or otherwise renders your representation unreasonably difficult, which leads to a breakdown in the attorney-client relationship. And so I think that we all grapple with this, and I think that your question earlier really spoke to that, right? Like, when is it that your client needs more time, resources, and patience, and when is it that you need to withdraw? And that's a challenge that we face all the time, right? And I think it's also very, very challenging in the right to counsel world that we're in right now, right? Like, in a perfect world, we would be able to devote as much time and as many resources to the zealous representation of our clients, but that's just not the world that we exist in right now. And it's not healthy to be able to, you can't do that for every client, and you'll burn out so fast if you try. So a few years ago, there was an article that sort of went around about right to counsel and withdrawing from clients' cases, caused a little bit of an uproar, right? But I think that the position was that there should be conditions that our clients have to agree to in order for us to represent them, right? And that's not what right to counsel is about, right? Doing something like that would place barriers on our ability to represent people. And it's I think ableist, right? Like, you have to do these things that I want you to do for me to represent you. I will not accommodate you in any way. That's pretty ableist, and not a way that I want to practice law, right? And so I think that you really need to balance, do I have the time, resources, and energy to maintain this relationship? Or is this a situation that I cannot possibly ethically or emotionally continue to represent this person? And it's really hard, and I think that there's a huge stigma around withdrawing from cases, especially in right to counsel. I think there's also almost like a scarlet letter when you see that another legal services organization has moved to withdraw from someone's case. It's like a huge red flag, I find, right? And it could be that the relationship was never there, or it could be that this isn't something you want to get into. And I think that's one of the hardest parts of our job, right? That doing the balance, weighing your ability to continue to represent someone with your ethical obligation to not present frivolous legal arguments to the court, or I had a client once who insisted that she didn't owe money to NYCHA, and the amount of time we went over the ledgers and her rent receipts, and just it began to be this situation that was so toxic for both of us, because I would explain to her that in order to show that she didn't owe the money, we needed physical proof. And she just thought I didn't believe her, and it became this horrible toxic relationship. She insisted on going to trial, and this was back before the HSTPA, where you had to pay your money in 5 days or get evicted. And it became a situation that was so untenable for both of us that it was the first case that I ever withdrew from. And I remember after I withdrew from the case, just feeling like this weight had been lifted off of my shoulders. It's such a terrible thing to think about, right? Like, because you feel like you're abandoning a client in a time where your expertise could help them. But there are often times that no matter how many times you explain to someone that this is not something that you can present to a court, it just doesn't get through. And so I think that it's hard for legal services, for anyone, I guess, to move to withdraw from a case, but it's necessary sometimes.
I'm very concerned that some right to counsel attorneys move to withdraw too frequently. I mean, I have the privilege of being in a project, a mental health law project, where we have time, we have caseloads that recognize that our clients have a lot of needs. But one of the things that concerns me about right to counsel is the pressure to have high caseloads. I think means that people are withdrawing from cases for tenants with disabilities, elderly tenants who are taking up too much time, too difficult, hard to get in touch with. And I do not think that's appropriate. Because and I blame right to counsel, I don't blame the recipients of right to counsel funding. That they are funding a program that is not accessible. It does not allow organizations to create accessible legal services programs to support people who need it. So my take on motions to withdraw is please try to not do it, if at all possible. I've only withdrawn, I think, 4 cases in 19 years. But like I said, I spend most of the time in the mental health law project. And we have lower caseloads and a lot of support for clients who need a lot of time.
I have a question and a comment. So in Brooklyn, there's a lot of tenants who, once they receive a marshal's notice, they're nervous, they have a lawyer, and now in order to, do the order to show cause, they have to relieve the lawyer. So I, a lot of time, encourage them before you get to that step, try to reach out to the lawyer.
Mm-hmm.
Of course, you have more than one case, so you might not get the lawyer right away. they're very anxious and they're nervous and they're scared. And if it's the first date, I really try to encourage them to come back before taking a lawyer off the case, especially if they need the lawyer, you know? And so just saying, is that the right thing to do at that point? To encourage them to try to give it more time, correct?
Yeah.
And I think like what I'm talking about is are people who are vulnerable in some way, like have a disability, elderly, you know, if there's a client who does not seem to have any like functional limitations and they just want to get rid of their lawyer because they want to go to do the OSC themselves, like, I think that's different, you know. I think the question for me is like, what is the likely outcome of withdrawing? You know, if somebody's on the second floor of housing court ready to file an OSC and they discharge their attorney, they're gonna file an OSC, but, you know, if it's somebody who has a serious mental illness and keeps getting admitted to the hospital and they're not even necessarily gonna know they got a marshal's notice. So it's just a different circumstances.
So you mentioned the accounting scenario, and I believe you just referred to a mental health scenario. What other scenarios typically would the motion come up in?
To withdraw from a case. I think it, like, I agree with Dinah's assessment that, like, right to counsel is real, and the pressure to close as many cases as you can. I mean, I think that a lot of times there are people that are encouraged to withdraw if a client disagrees with your assessment of a case, or isn't getting back to you, or can't, like, doesn't have the ability to hang onto a phone for a very long time, right? Like, that is a person that's vulnerable, and that is the type of person who shouldn't be withdrawing from their case, right? Like, someone who isn't contacting you because they continue to lose their phone or get it stolen, that is not, like, that's not what the spirit of this is about, right? Like, that person probably needs your help more than someone who is presenting a totally frivolous legal theory, right? I think that I mean, I've only ever withdrawn from 2 cases, so I'm not like the model of
I think if somebody just like disappears, one of the cases where I withdrew, the client was admitted to a nursing home, but I couldn't find out what nursing home. And his sister, who had not been involved in his case, I did not know her. She wouldn't tell me where he was to protect him, and our social work department like called around a bunch of nursing homes and couldn't find him. They probably shouldn't have told us where he was. He was there, and based on his medical history, we suspected he would not be getting out of the nursing home, and so we did try to find him, but we couldn't find him, and so I moved to withdraw, because obviously you can't continue representing someone if you don't know where they are. If I had thought he would get out of the nursing home and we would need to save the apartment, we might have put more effort into it. But he was terminally ill. And then one of the other cases where I withdrew was a client who was not mentally ill, he was just impossible. And I tried everything. Boundaries, limitations, structure, and he just was very committed to a factual theory of his case that I was not going to present in court. Was not able to work it out, and withdrew with an enormous sense of relief. But he was not a vulnerable person. He's one of those people who would probably stubborn his way into a better outcome than I could get for him. So I didn't feel bad about that. Yeah.
So you mentioned the pressure of right to counsel on the attorneys of closing cases, and then also the juggling of many cases. I work at the Manhattan table, and one thing I frequently see is some emergencies happening, but the attorney's not realizing that these emergencies are happening because of the juggling of the other cases. So in a case where, similar to my coworker mentioned, the tenant is completely competent would you suggest the better suggestion be reaching out to a supervisor on the attorney's end to try to get this emergency rectified? Or if the tenant is completely competent, relieving the attorney and kind of doing it themselves?
I don't know, that's a tough one.
Yeah, I feel like I would rather, personally, I'd rather have my supervisor email me and be like, someone from Housing Court Answers called me and said that you're ignoring your client, than getting an OSC in the mail or on NICEF that my client wants to fire me.
Okay.
Personally, I would rather have you contact my supervisor,
Mhm.
but that's not,
Yeah,
everyone in the room probably wouldn't say that.
Right.
I think it really depends on the relationship that you have with the attorney has with their supervisor.
there's no way you can know that, so,
Yeah, right.
yeah, yeah, that's, yeah, I don't know. I agree with Meg, I'd rather hear from my supervisor, but.
Okay.
That's a difficult position that you're in. I totally recognize that, and I wish I had a firm answer to tell you, but that's how I feel personally.
Any other questions? All right,
We're done.
Yep.
Yeah,
thanks, everybody.
thank you. Oh, don't forget to, you have to like fill out when we ended. I would just leave on the side of saying 4 o'clock. That seems unethical. 3:40 is the time that we ended.
That's what I'm saying.